Hello. Hello, Adele.
Hello.
Hello, Lizzie.
Hi, how are you?
I'm well, and you?
I'm good, thank you.
Okay, that's cool. Lovely, lovely. Okay. Shall we wait as we normally do a few minutes for people to arrive?
Yes, yes, that's fine with me.
Don't go away. Just hang on. We will be back in a
Will
few
do.
minutes.
Will
All
do.
right. Okay, Lizzie, Queen, good evening. Can you hear me?
I can hear you from my side. Good evening.
Hi. Queen, are you there?
Yes, I can hear you. Sorry.
Very cool. That's great, man. Okay, so it's only the two of you so far, and we are writing exams. When is the exam?
That's next week.
Next week. When next
Yes. Just need to check what date.
week?
My brain is a little slow. I had another exam today.
Oh, I see. Okay, you had an exam, huh? Yeah, no. That's
It was my first
dedication.
one.
So just give me the date of the exam.
Hi, Rayan. I think it's the 18th of November.
The 18th. That is next week, Wednesday.
Yes.
Yep. So this is your last class, I think.
Is this our last or our second last? Because we'll have
second last.
Second last, because we okay. That's what I just wanted to clarify. This is our second last class.
Queen, you should just confirm that it is the 18th, eh?
Yes, it's the 18th.
Okay, thank you.
So it leaves us with very little time left. And I think what we must do is we must continue to go through exam questions. And for this evening, I'm going to present another exam paper on labor law. Using the very same textbook from another institution, also at tertiary level. And then it's interesting to see how the organizers and the lecturers there prepare questions on the test. Can you both see this question? Can you see my screen that I've shared?
Yes.
Okay. Okay, so the first few questions are multiple choice. In terms of enforcing the Basic Conditions of Employment Act, the Labour Court may A, make a compliance order and order of court, make orders for payment of outstanding amounts owing to employees, C, require the payment of fines, D, all of the above.
Isn't it all of the above?
Yeah, pretty much. Let's just quickly go through this. What's a compliance order? And who makes that?
Isn't that a court order? So, yeah. I think it's a court order from the judge or whoever is. Yeah, it's a court order.
But then, so what A is actually saying is to make a court order an order of court. Doesn't make sense. So my question now is, which official, enforces the provisions of the Basic Conditions of Employment Act?
Will that be the CCMA?
No. And the CCMA is for disputes and so on, right? But there's another official that's often overlooked and not actually used as they should, in terms of people not understanding that there's a quicker remedy if you use this way out against an employer who's in violation of the Basic Conditions of Employment Act. So the BCA regulates minimum working conditions, and the law understood that it's quite possible that employers were going to flout these provisions, and it would be, quite burdensome for you to go through the CCMA now get an employer to comply. So it has introduced this official known as the labor inspector, who is charged with a number of things, including the monitoring and the enforcement of provisions of the BCEA. So they have that power to come out, to enter premises, to inspect documents, to follow through on complaints. And if they are satisfied that an employer is in violation, that they can issue a compliance notice or a compliance order. Okay, so the compliance order is basically an order that has that has got a binding effect, and it has got teeth in it, so to speak, because the employer now knows, okay, if you want me to comply, you should take me to court, and that has been bypassed to some extent. Okay, that an inspector can come, he can hear, you will hear you'll get a complaint from an employee typically, and he'll go investigate the complaint, and he will then go out to the premises if it's feasible, and if he's now satisfied himself that the employer has violated a condition of the employer Basic Conditions of Employment Act, the inspector may issue a compliance order, and that is a number of things. It can issue fines also, the labor inspector, and the employer is then given a short opportunity to comply with that compliance order. All right, and if the employer doesn't comply with that order, Lizzie, what now? Inspector comes out, he gives them a fine. So he says, you better pay these people overtime. They've been working overtime, and I've come out to you now, and I can see you haven't paid them as you should, in violation of the BCEA, and you must. So he issues a notice, a compliance order, and the employer must then comply, failing which the labor inspector can apply to court to make his compliance order a proper order of court. Okay, so all the powers the labor inspector has, obviously the labor court will have that as well, and more, to the authority to do all of those things. So compliance orders, orders for making payment of outstanding amounts that are owing and require the payment of fines. So quite right, that is what the labor court may also do. Okay, we move on. Which one of the following statements is not an affirmative action measure? A, to further diversity in the workplace. To further diversity, to make, to increase diversity. B, to ensure that employees receive compensation for injuries sustained in the workplace. C, to ensure equitable representation of suitably qualified people from designated groups. And D, to identify and eliminate employment barriers that adversely affect people from designated groups. Which one of that is not an affirmative action measure?
That'll be B.
Okay. And what is your thinking there? Why would you say B?
Because when it, like B, that has to do with COIDA,
Yes.
and injury on duty, so that has nothing to do with affirmative action.
Fantastic. Okay. Which one of the following statements is incorrect? The BCEA establishes and enforces basic minimum conditions of employment. B, gives effect to the international standards. C, ensures decent work for children under the age of 15. And D, protects working relationships by prohibiting exploitative practices by employers. What do you think, Queen?
I think it's B.
B, huh?
Yeah.
Okay.
I don't think it did affect international standards.
I can't hear you so nicely, Queen. Can you just speak into the mic a bit?
Let me remove the F. I think it's B because I don't. It gives the effect to international standards. It's all about the like usually here in South Africa.
Mm-hmm.
It deals with what's happening usually here, and also I don't know, but I think it's B. It's
You think
incorrect.
It's B? B is incorrect. What do you think, Liz? Do you agree?
I do agree with her. I do agree with her. Because I was thinking C, but I know that kids underage, they can work, but there's special conditions for them that need to be met. So I'll go with B in that one.
Actually, B is in fact, partly correct. They're both a bit vague, but by implication, the LRA and the BCA also does say that, when we're making laws, the LRA says that, the lawmakers, they must, and the Constitution also says, the Constitution, that you must consider international law when you're looking at the Bill of Rights. Okay, so our whole system, have you heard of WLO? WLO. Anybody?
No, not from my side.
No.
Okay. So the World Labour Organization, that's what it stands for, and it's a treaty to which South Africa is a party. Okay, and we look and we seriously consider international laws and international norms, and we're also members of the UN, United Nations. So definitely, when it comes to things like this, we try to make our law, in line as far as we can, considering our own constitution and our own objectives and our own country, to measure up to that standard, okay, of international legal norms that are reasonable. So the BCA is in fact there to give effect to international standards. So if you look at it, all has to deal with, you need to read this properly, it gives effect to international standards. So I guess in a broad way, it's true. C says it ensures. Let's look at all of them. A, it establishes and enforces basic minimum conditions of employment. I think we can't disagree with that, right? That's one of the main objectives. C, it gives effect to international standards. Okay, so it doesn't say that it, it incorporates it directly, but it gives effect. These are different words. C, it ensures decent work for children under the age of 15. And D, protects working relationships by prohibiting exploitative practices by employers. So out of all of that, C appears to be the one that is misplaced here, because the BCA doesn't ensure decent work for children under the age of 15. That's not one of its main objectives. In fact, says that children under 15 should not be working. Okay. There are, of course, exceptions to it. Okay, they can. So the purpose of this act is not to ensure that they get decent work. It's to promote, not to promote, but to permit exceptional cases where children under 15 may work, and they can only work under very narrow circumstances. There's a distinction, as we will see later on in the act, between children under 10 and children over 10. Okay, they can't do any work that is harmful to them physically, morally, intellectually, spiritually, anything like that. A child under 15 cannot do that kind of work. It must be appropriate. Okay, and the younger you are, the more onerous the burdens on the employer to give work conditions to them and times to them that are allowed. So children are not supposed to be working under 15 or school leaving age. And if they are very narrow categories, they are allowed to do things that are appropriate for them and not anything that can harm them in any way. So here, it doesn't ensure decent work. That's not the main purpose. It just regulates the exception of those limited cases where a child under 15 can work. Okay, a child under 10 can also work. Okay, in the sense that not work as we understand it, but may be allowed to do very limited kinds of things. I mean, you see children act in adverts and promotional things, right? So that is those limited circumstances. We'll come to that in due course. So it is more likely to be C than to be B, guys. 1.4, in regard to who has the onus in proving unfair discrimination in a case, which one of the following statements is correct? Okay, now let us just quickly go back. Can we recall unfair discrimination? What is it about? The Employment Equity Act, the Labor Relations Act, the Constitution. Okay, there's various provisions about how you're not allowed to unlawfully and unfairly discriminate against people on either listed grounds or non-specific grounds. Now, in regard to who is the onus of proof in proving unfair discrimination, which one of the following statements is correct? A, to prove unfair discrimination on a specified list or ground was in fact fair, the onus is on the employer. Does everybody understand what this is about? To prove unfair discrimination on a specified ground. Now, in the Employment Equity Act, in the Labor Relations Act, in the Constitution, there are those 16, 17 grounds that are listed as considered to be an unfair ground of discrimination. Race, ethnicity, color, creed, religion, beliefs, sexual orientation, gender, pregnancy status, you know, the 16 or 17 grounds. So if you are alleging discrimination, it is saying here, to prove unfair discrimination, the question is, who is the onus to prove? Where in an unfair discrimination case on a listed ground, the onus is on the employer. Okay. B, to prove unfair discrimination on an unlisted ground, in other words, it's on the employer. And unlisted ground means that is not those one of the 17 that are mentioned in the Employment Equity Act or the LRA. And yes, sorry. Yes, Lizzie.
Oh, sorry. No.
Were you saying something?
No, I wasn't saying anything. I was waiting for you.
Oh, no. Let me finish it and we'll have a discussion about it. This is good. It's refreshing our memory about unlawful discrimination again. So let's make sure you can see my page. Can you see my page?
Yes. Thank you.
So to prove unfair discrimination on an arbitrary ground, unlisted ground was in fact fair, it goes on the employer. C, to prove unfair discrimination on a specified ground was in fact fair, the onus is on the employee. And D, the onus is on the employee to prove unfair discrimination on both listed and unlisted grounds. So who has the onus to prove in an unlawful discrimination matter that it was fair or not? This is basically what the question is saying. Any thoughts, guys?
I think it's the employer.
We know it's the employer. Okay. Lizzie is saying employer and Queen is saying employee. Okay. Now, where is the trick? It's a nice question. It's a very nice question. It's really testing you now. You see, if you're going to remember what is unfair discrimination, it's you saying that there's no reason for you, justifiable reason for you to treat me this way, right? So you can say, now the Employment Equity Act mentions all those grounds, right? And if you, once you mention that ground, then who bears the onus? So there's two scenarios here where you have, as the employee, alleged that, look, I'm being unfairly discriminated against on the grounds of religion, for example. Is the religion listed over there in the Act?
Yes, it is.
It is, right. So that
Yes.
is a listed ground. Listen to this, guys. It's a listed ground. Right. So now you've been very clear in your claim as an employee that, look, I think they are discriminating against me. It's only because I'm a Muslim or a Hindu or whatever. But now sometimes you can also say, I've been discriminated against, but you don't mention the ground. So the employer also has no idea why you're saying that or that you are saying that the employer is discriminating against you unfairly. Okay. Now, the minute you say in unfair discrimination matters, just like unfair labor disputes, the onus goes on to the employer. Okay. Now, if you are clear on your ground, then the onus is on the employer very clearly. Once you've said I've been discriminated on a specific ground, okay, then the employer clearly will bear the onus, because the employer will. Why are you saying, that you're being unlawfully or unfairly discriminated against? If you do not use any particular ground, if you do not base your claim on a specific ground, then the onus will start to move on to you, the employee. Okay. But in this case, the question is,
Okay, I understand.
so you must be careful about, did you, when you referred it, did you mention the ground, or you just saying, it's unfair discrimination and you don't specify? So the minute you specify, the employer bears it. The minute you don't, the onus will start to move on to the employee if you don't mention a particular ground. I'm sitting with a case right now, where this client, I think we don't know how to formulate it exactly, but she's suffering from a particular skin disorder. Some people have skin disorders where it's a dark color skin, but it becomes like liver spots on there. I don't know if you know what I'm talking about. What's it called? There's a name for it. Leukoderma, I think it is. And her argument is that, I have been working here and I joined so many years ago, and I applied for promotions and applied for positions, and every time I was overlooked. And yet people who were not even, a year before me and not as qualified as me were given the opportunities for promotion and improvement in the company. I feel I'm being discriminated against. Now, if you were that person, what would you say? Would you say I'm being discriminated on a specific ground? Or would you just say, look, it's unfair discrimination, and not specify an unlisted ground?
I'll claim it under unlisted ground, because I don't think it's listed as one of the grounds in the Act. But she can take it further.
Now, it's interesting that you say that, because there has been a case under the heading of disability. Now, some people have physical disabilities, and most of us understand disability to me actually like a physical disability, right? You can't walk, or you're impaired in some other way physically. And there has been some cases like appearances. People look at your appearance and they discriminate against you. What happens if your body's got a lot of tattoos on it now? And must you now also be discriminated against? So under that heading of disability, I don't know, I'm thinking of maybe we put it under that heading and try referring it as an unlawful discrimination on that basis. So
my only argument will be that's the whole technicality. Is it really a disability? if it's because maybe it's like because I see like with guys who suffer with like eczema, like severe
Yes.
eczema where the hands are like they've got like sores everywhere. Is it really a disability or is it like a illness, like a short term or whatever kind of illness? Can be classified legally as a disability?
Now that is the whole argument. That is the whole argument. I've been looking at case law, and that is how we find the answer. We look at case law. We see how the higher courts, how the labor courts have interpreted these things, to include that. Now remember, the onus is, it's like, how can you prove, like, you must prove as the employer now once you list the ground, that you did something that was fair. So I'm thinking we should use that. The other route is to refer it as an unfair labor practice, Now, remember unfair labor. Because now I don't know, I'm looking at the evidence again to see, like, because when you say that, you must say prove, or if it comes to that, the employer must show, well, this lady or this person had the skin disorder, but we never took that into account when we failed to promote her or failed to advance her or, give her to discriminate against her. So one must just be careful. I'm speaking in all the cases here, the courts are very careful to look at that, to see on what ground you are referring the unlawful, discrimination matter.
I think you have a very interesting case.
Yeah,
I would love to know how it ends up, but that's a really interesting case. Yeah, but I think you do need she needs some sort of proof where clearly it says that you didn't get a job because of this. You can't assume that it's because of the skin disease, but it will be interesting.
No, for sure, because, an employer, I told this client that, look, try and get this matter, resolved through grievance. You must file a grievance with your employer and try and come to the bottom of it. And she did. And she said, look, how have I been treated here? I've been overlooked. I've been told to withdraw some applications, for better positions. People, you said you're not going to appoint to a position, but then afterwards I find out that there are people that were appointed, and I've been overlooked. And the employer will now have to justify that. But it's now hard to say that you were discriminated, and remember, what is the one defense that an employer has to a discrimination matter? In this paper here later, this test paper, this question paper, we'll see later on when we come to it. But what is the defense an employer has? He's got very little defenses. If there's evidence that he discriminated against somebody.
Yeah, he needs to justify it.
Yes, we call that an inherent requirement of the job.
Inherent requirement, yes.
All right. So some jobs, discrimination is important. You have to. If we are to discriminate, if I'm a company and I want to employ bus drivers, I can't. Is it unfair of me as an employer to say that, look, you have to have good vision, you have to have working eyes. You can't be blind. So if a blind person says, no, but you're discriminating against me, right? So I could argue that no, but it's an inherent requirement of the job that a bus driver must have sight. So therefore, I have to overlook the people with that disability of blindness. So we will come to that in a moment. But to prove unfair discrimination on a listed ground, the onus is on the employer. Okay. Next question, 1.5. With a reference to working hours prescribed in the BCEA, the maximum number of hours that an employee is permitted to work in a week is how many hours? A compressed working week.
Five.
Huh? Say again? Queen,
45.
were you saying something? 45.
Can you hear me?
Yes, no, just speak into the mic, please. I can hardly hear you.
I think I can't hear you. That's why I'm putting a speaker. I mean the earphones.
That's much better.
I'm saying it's 45.
45, yes, that's what the Act says. Yeah. So in that 45 hours, what are you entitled to further into that? In a working week, 45, it comes to 9 hours per day. But what are you entitled to? You entitled to?
You can't work more than 8 hours a day.
Yeah.
And then,
So,
yes.
well, that is only half true. You can work more because now, if you work overtime and then
that's limited as well.
right, so
yeah,
you entitled, it can happen, but you should be paid for that, and there are things that apply.
yes.
But in your compressed working week, 9 hours per day, you are entitled to a lunch break, a rest period. All right, which can be broken up. So, you know, people break that up. They will take a 45-minute lunch and a 15-minute tea break and so on and so on. Okay, so you're entitled to those rest periods. Okay, but 45 hours is the compressed working week under the BCEA. Question 2. What are the 5 core terms of employment that cannot be varied, cannot be changed, unless such variation is more favorable than the minimum standard allowed by the BCEA? Okay, so these are the 5 things that cannot be changed unless they are more favorable than what the BCEA allows. Good evening, Jody. I didn't see you there.
Hi, how are you?
Well, thank you, and yourself?
I'm good, thank you.
Good, good. Okay. So what are those 5 areas, guys, that cannot be changed unless the change that you effect is actually better, an improvement on the minimum that the BCEA allows? What areas?
I think leave is one of them.
Leave, okay, yes.
Yes.
That is your annual leave, like for example, your 2 annual leave, yeah, your 2 weeks annual leave, yeah.
Yes, and I think we touched on the working hours.
Working hours, number 2.
Oh, do you want all of them from me?
Well, I'm looking to you guys for answers now. Come, the exam will be coming, and you know, you should have an idea. That's 2 of them. What about annual leave? We mentioned working hours, maternity leave.
Maternity leave, I was gonna say.
Right, maternity leave. What is the deal on maternity leave? How does that work?
You get 4 months.
4 months.
4 months.
4 months max
4
maternity
months.
leave. Yes.
Right, and failure to, or an employer dismisses you by failing you to allow you to come back to work as a dismissal, or if he dismisses you for any reason that is related to your pregnancy, then what? Even your intended pregnancy, you may not even be pregnant, but he finds out that you want to become pregnant, and now he wants to find a way to get rid of you and dismisses you because of that. What then becomes to that? What is anything particular about that?
It becomes an automatic unfair dismissal.
Correct, Lizzie. It's an automatically unfair dismissal. Okay, 1871E, I think. which says that, any reason related to pregnancy or an intended pregnancy is an automatically unfair dismissal, and it's a punitive type of dismissal, and a punitive remedy is also given for all automatically unfair dismissals, up to 24 months compensation for that kind of dismissal. Okay, so we got the working hours, the annual leave, the maternity leave, obviously sick leave, right? Then there's one that many people forget, night work regulation. There's very particular rules relating to working at night. Can you work at night? You can, if there's agreement. If your employer wants you to work at night, the employer must provide transport for you to your home and also provide food for you if they want to insist that you work during the night. Okay, so that has also been regulated. Now that is an example where a labor inspector can be called to the scene if an employer refuses to do that. He wants his workers to work during the night, but does not want to provide transport, for instance, or does not want to provide food, for instance. And, this is how it will happen. An employee will report such conduct, and the labor inspector will come, will see what's going on, will confirm the complaint, and will then issue the employer with a compliance notice and or a fine. Okay, depending which provision of the BCEA the employer has violated. Okay. Now, with reference, everybody clear on that? With reference to the Employment Equity Act, explain the difference between the following concepts. It's a nice question for 10, well, it's 5 and 5, 10 marks. Formal equality and substantive equality. Formal equality and substantive.
I actually read about this. Formal equality focuses on protecting every individual's rights against discrimination.
Right, Joe. Okay. And views individual ability and performance is the only factors that are relevant for achieving success in society. Now, you see, what is the difference between formal compliance and substantive compliance? These two words are used a lot in law, formal justice, substantive justice. It sometimes means like it's an outside thing, an outward and superficial thing sometimes. Formal equality, but not substantive equality. But that is what you've said there is the correct definition, where it focuses on protecting, the individual against discrimination and looking at those individual factors that affect the person. And we believe that, it is according to that definition that is how you will attain equality, through formal equality. Okay. And substantive equality? This is where they look at the behavior and the patterns of behavior of individuals. Okay, according to a group, and we to get equality now in terms of groups. Okay, so when we look at affirmative action, it says that we will not only look at individuals, but we will look at the groups to be able to get our equality targets in the workplace. Okay. So one of the objectives of affirmative action is to bring about diversity, to correct past imbalances. So it will now automatically give what we call PDIs, previously disadvantaged individuals, opportunities. Okay, to correct past imbalances. and we look at the groups rather than individuals. Whereas in formal equality, we focus on the individual. It's a way to also explain the so-called difficulty that employment, that affirmative action has brought about. Because on the face of it, affirmative action is discriminatory on the face of it, right? Other people are not given chances. We don't look at formal equality now. If that is the case, then some people, people should normally be given positions based on merit, based on the ability. Okay, so on that grounds, on that approach, and on that view, substantive or rather employment affirmative action is not then formally equal. It looks at addressing other issues and will now lawfully discriminate against certain groups and certain individuals, so that to correct a previous imbalance. All right. Is that clear? We move on to this question here now. Question 3. Ronald owns a motor vehicle workshop called Ronnie's Custom Cars. Okay. Ronald wants to employ his 13-year-old nephew on the weekends at the workshop, as his nephew still attends school during the week. Okay. Like Ronald, his nephew has an interest in cars and in building them. If employed, Ronald's nephew would be required to help him with removing old vehicle parts from cars and replacing them with new parts. Okay. So here's this guy who wants to employ his nephew who's 13 years old. Can he do it? The guy's still at school. Now let us look at the questions. And part of the job would mean that Ronald will have to remove car parts and put in new parts. Okay, so what is that telling us already? It's a bit of an element of danger there, isn't it?
Yes.
It's a dangerous. It's not a. Yeah, it's a bit of. It's a job that will with risk and safety issues that may come up. Answer the following questions. For 7 marks. Ronald seeks your advice on whether employing his nephew would be lawful. Summarize number 1, 3.1.1. Summarize the protection that is built into the BCEA to protect children. Okay, I think we already alluded to this in the previous question. So the BCEA doesn't allow children basically under the age of 15 to work. Okay, or which is the minimum school leaving age, which is 15 or grade 9. Right, so it's not that you can't work, you need to then leave school or be 15 years old. So he can't therefore be employed strictly on that basis. Okay, so that is a law on its own that doesn't allow children under 15 to work. Okay, you have to be 15 and upward. You need to have left school or at least pass grade 9 to be able to take up a job. Okay, but under 15, no. What else? The Act also prohibits a child who under 15, and limits the kind of work that the child can do, provided that the work they do are not against the child's, safety issues, and put the child at risk, and would alter or change prejudice them in their education or their physical, spiritual, moral, and social development. Okay. So that is basically what the Act says. Under 15s are not normally allowed to work. They can't work unless they either have to be 15 and older, or they have left school, grade 9. The Schools Act actually prohibits that, so therefore the child must have left the school at that age. And any work that he does, if he's older than 15, you must clarify that if he's older than 15 even, and he has left school, that the work he does mustn't be work that is against his development. Whether that is educational, physical, mental, spiritual, or moral, social well-being. Okay. So what happens if you employ a child that's under 15 now? If Ronald can, Ronald basically, we must answer that question comes up later. Yes.
It is a criminal offense.
Yes, okay. It's a criminal offense, right? It's a criminal offense, and when we see young children on the road sometimes, doing dangerous things, it is actually something that we must report to the Department of Social Welfare. Okay, so it's the state's duty. If a child is not being cared for or being neglected by the parents or the guardians, that they will take the child and put the child in a place of safety. Okay, but children shouldn't be forced to work, and if they are, 15, even if they're 15, the work they do must also not be harmful to them. Okay. Next question, with a reference to regulations by the Department of Labor, discuss the work that children like Ronald's nephew are allowed to do. Okay, so how old is he? 13 years old. What can he do? So children who are younger than 15, okay, who are still at school, grade 9, can do things like advertising, artistic or cultural activities. They can collect funds, like for fundraising organizations. They can do voluntary work for churches, charitable work, amateur sports clubs. Okay, or any work that is appropriate for them that is part of their schooling. Okay, so I mean, a child who's 13 years old can perhaps wash your car. He can clean the garden maybe, or you can do something light that's appropriate for the child. And to give them hard labor it's prohibited, it's dangerous. Indicate whether Ronald could employ his nephew to work in his workshop.
I think it ties back to what we've already touched on. Because he's under 15, it's illegal for him to actually employ him.
So it doesn't fall in those categories allowed even. Okay, and these are very limited categories, right?
Yes.
Very limited. They can do only light things, and an employer will be in big trouble if he does that. So this is part of protecting children. As you can see, the other multiple choice question was to ensure good working conditions for kids. That's not the case. The case is it's actually to protect children from hard kind of work, and so they're not allowed to work really, except for these menial things. And if he does it, he'll be in trouble. You happen to be in the workshop one day when one of Ronald's clients, Bob, is getting his car fitted with new parts. You overhear from Bob that he would like his daughter to audition for an advertisement about a children's television show. On what condition may children like Bob's daughter engage in this type of work? So again, there is again the act making clear, like, can a child do this kind of work? What are the regular the conditions for this kind of work?
I think you touched on it. With advertising, it's part of the jobs which they can do, but it comes with its own limitations. I know there's like specifications as to how many hours they can work.
Yeah.
Like rest periods in between and all that. But the parent is still like the guardian. They've got a bigger role as well when it comes to that.
Yeah, that's broadly. I mean, but how many marks was that for? 5 marks. So here you're going to mention things like, look, if the child is to be employed, the guardian must obviously represent the child, right? The parent or the guardian of the child. And the monies cannot be paid to the child, but must be paid to the parent or to the guardian. Furthermore, regarding the age of the child, if the child, is older than 10, then they can work up to 4 hours only per day. Okay? And if they are younger than 10, they can work for only up to 3 hours a day. And if they work for 2 hours straight, then they must be given a rest period. They must be given a break. Okay, and that's for the children that are over 10. And for children that are under 10, if they work for 1.5 hours, they must be given a break as well. And over and above that, you must also provide nutritious food and drink to children who are working like this. And you must also provide safe areas where these children can play as well between work. So it's quite onerous, as you can see. And also transport must be provided to the children between their home and their workplace if their parents are not doing that. Okay, so there's a number of things, as you can see there. The main thing is, if the child is under 10, it's more oneruses, more difficulties. Over 10, it's 4 hours maximum. Under 10, 3 hours. Breaks every hour, 4 hours work for over 10-year-olds. And under 10s, every 1.5 hours work break. You must provide the food, you must provide safety and safe working conditions, play areas for the under 10s, and also transport if the parents are not providing that. Okay, one day you receive an urgent call from a friend. Your friend tells you that he resigned from his employer 1 month ago, but the employer has ignored his resignation and is forcing him to work. Advise your friend on whether this conduct by the employer is lawful or not.
I'll say it's not lawful
Mm-hmm.
for the employer, obviously, to ignore a resignation, especially if it was actually put in and then he gave enough notice, and he served his notice period. But it would be interesting to know why the employer is ignoring. Was it a written resignation or was it something said verbally in passing? So I feel the question is not really giving us much, but I'll say still it's unlawful.
Yeah, it's unlawful because you can't force anybody to work.
Yes.
That is the whole idea, forced labor. Although there have been cases, but these are criminal type employees. They would exploit foreigners who are here with no work permits, and lock them up in factories, and let them out, very rarely, or give them hard working conditions, long hours, and exploit people. Okay, now that is a criminal offense to do that as an employer.
I wanted to comment and say, like that friend, I wouldn't want a friend like that. You've resigned. Why are you still going back? Like, seriously.
No, that is that is under normal conditions, right? No one. Yeah. You see, you can't force people in especially if you're now an employee as defined under the Labor Relations Act. So this is those cases where, a couple of years ago, there was this guy in Durban who had a factory and he locked the people up there. And you're not allowed them to come out, maybe at the end of the day, they would be allowed to come out. And while he had locked them up, there was a fire. The place caught fire and some of the people died in there. And this man was criminally charged for violating the BCEA and also for causing their death later on. So obviously, you know, when you do that, you are going into a mode of kidnapping with the person now, you know, if you are holding them against their will like that. So it's you can't force anybody. Okay. So in a question like that, you would want to say, no, the BCA forbids forced labor or compulsory labor, and it is a criminal act to do it. Okay, here we come to a nice little question here on problem type question. The University of Downton places an advertisement in a national newspaper. The section of the advertisement reads as follows: matron for female residents required. Only female applicants with the necessary experience and skills will be considered. Male applicants will not be considered. Mr. Abbey applied for the position and was informed that he was unsuccessful as he is a male applicant and only female applicants were considered. He claims that the university unfairly discriminated against him. Discuss whether the University of Downton has unfairly discriminated against. In your answer, address the following aspects. Using only your own words or paraphrasing, explain the purpose of the Employment Equity Act for 5 marks. Okay, I mean, this is something you guys will be able to do, right? I mean, we've mentioned this many times, why the Employment Equity Act is there. The Employment Equity Act has got 2 major purposes, which you must broadly be able to identify, right? To achieve equality in the workplace, right? To prevent discrimination on the one hand, and to promote equality on the other. So on the one side of the Employment Equity Act, it prohibits discrimination on all the listed grounds. That is listed both in the Constitution, in the Equality Clause, in the Act itself there, the Employment Equity Act, as well as the Labor Relations Act. Okay, so it wants to do away with all those kinds of discriminations. So it expressly mentions certain things, and it deals with things even like harassment, like your status of your health issues. It could even be people with HIV, for instance. So it wants to prevent discrimination, and it also wants to promote equality, and that is where it deals with the question of affirmative action. Okay, and like we said, affirmative action is a type of justified discrimination, lawful discrimination. The law doesn't like or doesn't permit discrimination generally, but under this policy, under this act, it is considered that kind of discrimination where it will discriminate on groups, substantively. Look at the groups now, substantive equality, and make decisions based on that to bring about equality in the workplace. What are your views on that? Do you think that this is the way to go? Do you think it is necessary that we have such a policy? And what do you think will be the future of the policy? Shall we award and give preferences to people, previously disadvantaged individuals, which include black, colored, Indian, disabled people, women? Women is even mentioned. So what do you think that this policy, what do you think of the future of this policy? Hello?
Hello, we here.
Yes. I was just wondering, okay. What do you think? This is a bit of a deeper question, because obviously there's arguments for those who are not favored by the policy. They always are very critical of the policy. But now, if we were to judge this policy of affirmative action, very objectively now, and see and ask ourselves, what is the future of this policy? Do we see it always being the case that people are going to get jobs based simply on the affirmative action principle, or are we going to go back to that formal equality where we judge people, the individual's ability and skill, and that when we give jobs, we look at the applicant based on merit purely? Where do you think we'll be going?
Okay, from my side, I don't see it because I believe it's not working. Because I personally feel only a few people are actually benefiting from it. And it's a matter of time before the whole thing is just scrapped out, and then we just go back to basics. And then I also feel like you also feel some sense of pride, man, when you get your job on merit. Not because you fit the certain criteria and stuff. That's just me personally. But I don't see honestly, I'm at a point where I don't see the purpose of it. That's how I feel. But in the long run, I don't think it's something suited to us. It's not working for me.
Okay. You see, I mean, I was of the view, that it was something that was necessary at one point. But obviously, it was like it said, it was to address past imbalances. And a time will come when the threshold has been passed and reached, that it has now reached that point where previously disadvantaged individuals or groups would now have been, reached the point where the equalities and the opportunities that were denied them before, even as a group, would have now been reached, and that opportunities in the workplace must now be given to people on merit. So it's possible, yes, that that the system as it is now will reach that point where it won't be proper. Otherwise it will just be discrimination, unlawful discrimination, and unfair discrimination at basis. So it will take time, but yeah, we'll have to see how things develop. Okay. Now, what's the difference between direct discrimination and indirect discrimination? Which ties in with the question that I'm sitting with. Remember that case I told you about? What's direct discrimination and indirect discrimination?
I know with indirect, it's not intentional. Like you discriminate a person, but it wasn't the intention. Whether it's an ad which goes out for a position, it's not intentional. But then with direct, you are placing proper barriers to say, okay, I'm excluding you because of A, B, C, and D. I think that's yeah.
If we look at this example now, this man, Mr. Abbey, he applied for that position, right? What do you think? Was this guy discriminated against? As he's saying, well, we need to discuss it now, whether he was unfairly discriminated against. But yeah, do you think that he was unfairly discriminated against? And if so, was he directly discriminated against or indirectly?
You see, this one for me is a bit tricky because my instinct is to go with indirect, because I'm looking at the position that he applied for. They need a matron who'll be working with females. So looking at the environment itself, I think it's like an inherent requirement of the job.
Okay.
A female matron.
Okay. All those thoughts. We're going to come back to it. But I mean, see, the thing is, direct discrimination is where it's very clear that you're being discriminated against. I mean, to say that we don't want men to apply, it means they are discriminating against him on the basis of gender. Right? Because they're clearly asking, look, we only want females for this position. Or for another position, we only want this group or that group or this requirement, you know. So, but indirect discrimination means that it may not be intentional, and it's hard to say it's intentional, but it has the effect of discriminating with you, discriminating against the person, although it may not on the face of it appear to be so. Okay, where the criteria for the position appears to be neutral, but it actually affects a certain group or a group within a group. Okay, so it could be in this thing here. Yeah, it's perhaps, you know, one could argue it from both ways. How the effect of an advert of criteria of a job advert may have the effect of discriminating you not directly, but indirectly. Okay. So, for example, if I say I want people to apply for this position as a lab technician, but they must be between 18 and 30, and they must only reside in Langa, for example. So what am I saying here now? I'm discriminating directly for age, but indirectly what I'm saying is the majority of residents in Langa are black people. So I didn't say that, but by merely mentioning that the applicants must reside in a certain area, I'm indirectly saying that I actually only want people from that particular group, because most of the people live in that group, live in that area belong to that group. You understand? So this is how the difference between direct and indirect discrimination are. Okay, where it appears to be criteria that's neutral, but you know, on close examination, it actually is discriminatory. Discuss one of two possible grounds of justification that the University of Downton may rely on not to appoint Mr. Abbey.
This is where I come in.
Yeah.
I already mentioned it.
Yeah.
They can claim that it's an inherent requirement.
Right.
Of the job.
No, but yes, okay, you must discuss one of two. What is the other possible ground? Now, we're going to discuss it, but let's just look now at inherent requirements. So, on how is this an inherent requirement? What is the inherent requirement that they're using now?
Since it's a female boarding school.
Here you go. Right.
And they need a matron.
Yeah.
I think females will be more comfortable with having it.
Right. So that is the whole idea, right? That would be quite a justifiable argument that you know, it is a female hostel, and we would not want a male matron in charge there. Yeah, that could be like as you say, an inherent requirement. Okay, if you're looking for you know, somebody to as a model, you sell clothing, right? And you need a model that you sell maternity wear, right? Maternity wear, ladies' clothing for women that are pregnant. So now you're going to discriminate against other women who are not pregnant now, right? And it could be the inherent requirement of the job that this is the kind of clothing we sell, and we need people, women especially, in that particular condition, to be able to sell it. What is the other possibility? Inherent requirements of the job stuck out there clearly, but now what other possibility is there? We've discussed it already. It could be affirmative action also, right? Because affirmative action, if you look at the Employment Equity Act, it puts obligations on certain employers to ensure that representativity in the workplace. Okay, so it must have, for example, as people to give them opportunities, it must show in certain positions in a concern in an employer's workplace that there are so many people from the black group, the colored group, the Indian group, women, disabled people, all this and that. So it could be because the way that the affirmative action requirements were structured that, it had to be a female instead of a male. That could also be the other argument, although the argument that it is inherent requirement of the job makes a lot more sense. Can be more easily argued. Okay, because the workplace is a very different place to what it was before the Constitution. Right? We cannot think that the jobs that were, traditionally reserved for men are jobs that women will not be able to get nowadays. All right. In every faculty, in every industry, it's always been and still is a bit male dominated. And the Constitution and the LRA wants to change that. Employment Equity Act wants to change that. Okay. And we can see even the world wants to change it now. In the American history, it's the first time that there will be a black female, woman vice president. So there is strides being made in that regard. All right, last question, guys, before we're going to call it. Indicate whether you think that the University of Downton has, in your view, unfairly discriminated against Mr. Abbey in a direct or indirect manner, and provide a reason for your answer.
I'll say it's in an indirect manner.
Okay. But the first
when you say that, then right? I know I'm wrong.
No. See, law, because this is a nice question. One could actually look at it from both points of view, Yeah, one could say that he was discriminated unfairly against, directly based on gender. We already answered this. One could make that point. It was said male participants are required, female applicants are required, not male. Right? Or that it was done indirectly, directly, but it was as a requirement that for a female for the position was an inherent requirement of the job. So either way, you must just be able to justify it, like, either way. Yes, it was direct because you could argue that because they were looking only for females and not males, and the advert says clearly, right? Although in justification of the decision, it was an inherent requirement of the job. Okay, or it could have been indirectly, again, the same thing, that a female is required for this position and not a male, considering the job requirements, inherent job requirements. Okay, so you must just phrase your answer there correctly. Okay. Now, guys, is there anything, next week will be our last class, is there anything going through the notes here, guys, that you want me to cover? I'm going to try and find more labor law exam papers. But is there anything in particular that you're having perhaps want me to cover again? Or shall we just work through past papers?
From my side, I appreciate past papers. Okay, I've been searching and I'm not really finding anything. So this actually helps me to see how the questions can be structured. I know it's multiple choice, but this sort of forces you to think as well. But there isn't any, I can't find anything online. So I would really appreciate that from my side.
Okay, more of that. Fine. Okay. And you, Queen, or you cool, or shall we continue with the past papers?
Yes, the past papers, I think they're fine because it's a portfolio exam and it's my first time doing a portfolio exam.
I see.
So I think
So
it's
this is
better
going to
if
be online, eh?
Yeah, but it's a 24-hour
Time period.
it's not a 1 day. Yeah.
I see. No, okay.
18 and 19.
Okay, no, fine. Okay, guys, I shall try and find more exam papers. I have exam papers for my other labor law courses, like, you know, for LLB and so on. The questions there will be a bit more complex, but if you can master those questions, then this will be a lot easier.
Thank you very much. Looking
Thank you,
forward to
Lizzie.
the last session as well.
No problem. Thank you, Lizzie. Thank you, Queen. I'll see you next week, Monday evening.
Thank you.
Okay.
Thank you. Just my
Okay,
student number quickly. I
yeah,
type
put
in
it
the
in
message
there, yeah.
box.
All right, do that.
It
Yeah.
is not typing. I don't know. It's not typing on my side. Can I just give it to you?
Okay. Let me just put it in your Queen.
Because I'm using the
Musapito.
phone, but it's not ending.
So, what is the number?
4555
455
8647.
8647. Okay, done.
Yes.
Thanks, man.
All right.
See you then.
Thank you
Okay,
so
Queen.
much.
Bye.
Bye.